Counsel, the state court action here has been stayed for most of its existence. We now have a separate federal action. In that case, the district court recently granted summary judgment to Enbridge, finding that the attempt to revoke the easement was preempted by federal law, correct?
Yes.
So if we affirm the Sixth Circuit, that that will result in litigation in both state and federal court, correct?
The way that stands now is that there has been an adverse judgment in a federal district court, including rejection.
If we reverse the Sixth Circuit, I misspoke.
Yes.
Then there'd be two actions, a federal and a state.
Yes, the governor has filed.
So wouldn't it avoid waste to have these two actions proceed together in the same court?
The Attorney General and the governor has always been concerned about these two, about cases being not on the same track. The Attorney General and the governor.
Right, so assume you win here. Could you represent, or are you willing to represent, that on remand you will ask the state court to continue to stay this action until the federal action finishes?
There has already been a stay of...
I've asked you a very different question. If you were to win here, are you willing to commit that you will ask the state court to continue its stay pending resolution of the federal action?
I haven't talked to my client to be able to confirm that, but that's certainly something that we can talk about strategically.
And if the strategic is you want the state court to beat out the federal court, shouldn't we care about that? That was Justice Alito's question.
The Attorney General does care about staying in state court. She believes these are state...
Yeah, but it didn't act very expeditiously in state court.
It would be a strategic decision. At this point, there has been a second stay in order to see what the Sixth Circuit is going to decide. And then
one final question. You give us two grounds to reverse. The one is that this is not a statute of limitations. And the other is that even if it is, the presumption has been overcome. If you were to win, which is the easiest and most narrowest ground to win?
I think the easiest for this court is to say not to deal with the statute of limitations and the presumption issue, because we think that the text and the structure and the history here absolutely mean that congressional intent would say that even if there was a presumption, it would be rebutted.
Is there any way, some of them are clear on how to distinguish them, but he mentioned, Mr. Birch mentioned 4 cases that talk about losing a procedural right to proceed, Lozano was one of them, and there were 3 others that he mentioned. Can you distinguish each of those cases?
I think one of them was Lozano, definitely talked about what is or isn't a statute of limitations. There was no statute of limitations there because there was the opportunity for recovery, albeit adjudicated differently. I believe another one of the cases was Young, and there the court said it was a statute of limitations. It was, albeit a limited one, but the rights that were at issue in Young were priority and non-dischargeability. And those are procedural rights that were connected to a recovery and would have been lost. And the court did recognize the reason it was limited is because there were some equitable abilities to recover. Nevertheless, those very, very important rights for the United States would have been lost.
How about the tax case?
Beckler was a statute of limitations. There was just one exception. Beckler was also a case that was steeped in equity. It was about the collection due process hearings for state court for a particular kind of case where the tax court was going to be levying property. And that really mattered there because that was a context that was very friendly to the lay filer. But in both...
Thank you, counsel.